Thanks everyone for joining. Thank you to our panel speakers. We have quite a powerhouse of a presentation this afternoon, and we're glad to be able to present that. As many of you may know, Legal Services in New Jersey, we coordinate and support the statewide system of legal services, which provides assistance in civil legal matters for individuals with low income who qualify for our services. And this D. Miller Justice Series is a free webinar series designed to educate the public and stimulate thought on key social justice issues, economic issues, centered, of course, on New Jersey, topics ranging from the child welfare system to environmental justice to our most recent artificial intelligence and access to justice. And those video webinars can be, if you can't participate live, they exist on our website, so you can encourage you to go check it out when you can. The webinars are free. As Rachel mentioned, there's opportunities for CLE for New Jersey attorneys, and I am pleased and honored to be able to be with you all today to introduce the speakers for today's program. You know, for years, we've had the pleasure and the honor of having Professor Chen lead the constitutional law workshop at LSNJ's annual conference. But given the interesting times we find ourselves in as it relates to our current government and this year, we wanted to do a little bit more. And so the workshop is evolved into something that we felt could be compelling, grounding, hopefully encouraging, and ultimately something that folks would want to hear. So we opened up this concept, and now we have a panel with others from various perspectives on the law, experts providing unique perspective and advancing the civil rights of the people of New Jersey under the Constitution, addressing topics such as immigration, free speech, education, and we'll get to hear from each of the speakers as to what they've been up to recently before we move into the portion of the program which Professor Chen will lead. So let me introduce our speakers. Professor Chen is a university professor, distinguished professor of law, and Judge Leonard I. Garth Scholar at Rutgers Law School. He is the former dean of the School of Law in Newark and the former public advocate of New Jersey. Currently, Professor Chen litigates civil rights and civil liberties cases throughout the Constitutional Rights Clinic. And for the past 15 years or so, give or take, as I mentioned, he has led the conversation on constitutional law, a year in review for legal services, discussing the more impactful constitutional law cases at the state and federal Supreme Court levels. Michael Zuckerman is the Deputy Solicitor General of the Office of the Attorney General of New Jersey. He previously clerked for U.S. Supreme Court Justice Sonia Sotomayor and was a Skadden Fellow and Litigation Counsel at the Ohio Justice and Policy Center. As Deputy Solicitor General, Zuckerman represents the Office of the Attorney General before the federal and state courts and provides assistance in cases involving constitutional and appellate issues. Ezra Rosenberg is the Director of Appellate Advocacy for the ACLU of New Jersey. This is a new position, and he joined the team in 2024. And in this role, he serves as leader of the legal department and manages the ACLU's vast appellate docket to protect and expand the civil rights and civil liberties for all New Jerseyans. So we are very lucky to have each and every one of them. Tremendously busy schedules, wealth of expertise and knowledge. So we thought it might be worthwhile with so much happening. It's a whirlwind of federal actions and state responses. Coming from your various perspectives, I'd like to give each of you maybe about 10 minutes or so to talk about your recent Supreme Court experience or working on constitutional law issues for the folks in New Jersey, and then we'll hand it over to Professor Chen to lead the U.S. and state Supreme Court conversation. So let's start. I know the New Jersey Attorney General's office has been a leader nationwide in managing a response in New Jersey. The reassurances of standing on the rule of law against a storm of executive orders with various impacts on immigration and other areas. We know as recently as last week, arguments to uphold birthright citizenship. So if you can talk about some of that to the extent you can, or the immigration detention facility matters you've been working on, and you can start us off in the conversation.
Sure. Good morning or good early afternoon, everybody. Thank you for having me. It's very, very nice to be with you all. I'm Mike Zuckerman. I'm a Deputy Solicitor General. I'll just start with a quick caveat, which is because this is CLE and because our office is actively litigating many of these matters, I'm not going to be disclosing anything non-public. I'm not going to take any positions on things we haven't already taken positions on. This is descriptive presentation for me. So I'm going to hopefully bring folks up to speed at a bird's eye view on what's been going on. Certainly, I imagine others may comment or can comment. That's obviously their own perspective, but in terms of our office, I'll just be speaking, objectively about what's happening in these cases. So I will start with these cases that kind of look at the interplay between state and federal power in the year 2025. And the one that's been on a lot of people's minds recently is the birthright citizenship case. So, when you start with the text, of course, the 14th Amendment since 1868 has guaranteed to all persons born or naturalized in the United States and subject to the jurisdiction thereof. It says they are citizens of the United States. If you go back even prior to that, back to English common law, there's a concept called jus soli, which is basically a longstanding idea that if you're born within the jurisdiction of a territory, you're subject to that jurisdiction, you acquire the citizenship of that territory. This is also reflected in a federal law, the Nationality Act of 1940. It's been recognized by the U.S. Supreme Court at various times over the course of the last, centuries of constitutional history. So there's a case called United States versus Wong Kim Ark from 1898. There's a 1957 case called United States ex rel Hintopoulos versus Shaughnessy, a case called INS versus Errico from 1966, INS versus Rios Pineda from 1985. Even in 2004, in some of the post 9/11 cases, a case called Hamdi versus Rumsfeld, you see the court kind of acknowledging this doctrine and understanding in 2004. So the litigation takes place against the backdrop of a federal executive order, which has sort of two components that are most focused. The first declares that birthright citizenship does not extend to children who are born to a mother who is unlawfully present or who is lawfully present on a temporary basis, and a father who is neither a citizen nor a lawful permanent resident. So that provision itself kind of calls into question the citizenship of existing folks, though it itself doesn't direct immediate action. Then there's another section, Section 2, that directs federal agencies to no longer, after a brief ramp-up period, to no longer issue documents recognizing United States citizenship or to accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship. So a number of litigants came to court in the wake of that executive order. Some of them were states, some of them were not states. The case was argued last Thursday in the United States Supreme Court. What that argument was primarily about really was not the underlying validity of the executive order, although the oral argument, which you can all listen to, touches on that, but primarily about the availability of a form of relief known as a nationwide injunction, which is basically when and under what circumstances a district judge or perhaps even a circuit court can order relief that goes beyond the parties, the specific parties to a dispute. And these have been issued in other cases as well. The United States government in this case has a quarrel with the nationwide injunction here and also in other cases. And basically has a frontline position that kind of relief should never be available except beyond the actual parties to the case. They talk about the possibility that maybe it could be available through some sort of class action procedure in certain cases where Rule 23 would be satisfied. They don't concede that it's satisfied here. So huge questions remedially at this stage about if the executive order is unlawful, kind of what does that mean for the litigants. So that argument, like I said, was just last Thursday. So, I'm sure we will all find out more in the days ahead, but that's kind of an overview of where things are on the birthright litigation. There's also, you may have heard, a significant amount of litigation around kind of government funding. And I'll just say again, in the spirit of like CLE and just sort of the general doctrinal principles here, most of these cases, and they can be about different things. They can be about, there's a recent case about FEMA funding, about Department of Transportation funding. one of, sort of a core principle of federalism established in cases like Prince versus United States is a case that sometimes gets cited. Many of you may remember from the Obamacare litigation in 2012, NFIB versus Sebelius talks about this. The United States, of course, has a substantial amount of money to spend, and they have a spending power through the Constitution, but there are limits on how they use that spending power. So to give you an example, in the emergency response context, there's about $3 billion, I think, of federal funding that goes to the states. In Department of Transportation highway funds, it's like, I think, about $24 billion. And so there have been sort of memorandums or other documents issued by federal agencies recently suggesting that funding might be contingent on participation in federal immigration priorities, and the extent of what it's asking states to do is actually, or would be requiring them to do to obtain the money, is itself a bit vague. But the underlying principle that the parties are fighting about is the thing that Chief Justice Roberts wrote about in the NFIB versus Sebelius case, which is that there is a point at which the spending power becomes unduly coercive. I shouldn't say it's the only thing they're fighting about in this case, but it's one of the big constitutional issues. And so if you look back at that 2012 opinion, Chief Justice Roberts has this kind of memorable line about the time when financial inducement goes from mild encouragement to being an unconstitutional gun to the head. And so going back, and there are cases like South Dakota versus Dole, which is about highway funds and the drinking age, that basically says there's some line at which the funding conditions become so coercive that they pass the point as not just kind of pressure, but really compulsion. And so these cases are kind of testing the limits of that, and they're about the limits of that in the modern contemporary context. Of course, there are also other limits around federal spending, like they can't, and these cases bring those out too. You can't impose conditions that are wholly unrelated to the purpose of the federal funding program. The conditions have to be understandable. They can't be ambiguous. So all of these cases are kind of about those limits. We're going to find out more about what courts think about those limits in the course of this litigation, but that's the big constitutional issue, or one of the big constitutional issues that you're hearing about, and you're going to continue hearing about as these funding fights go forward. I'll say just a bit too about this case about the Elizabeth Detention Center and Core Civic and a New Jersey law, as I kind of pivot to New Jersey cases. So this is called Core Civic versus Murphy. It is a case, again, about kind of the interplay between state regulatory authority and federal immigration authority. So it takes place against the backdrop of federal contracts for private immigration detention. The federal government has used private contractors for both immigration and criminal detention, going back now about 40, 50 years. New Jersey does not use private, companies for general criminal detention. And then in recognizing kind of a history of poor conditions and problems with health and safety in private immigration detentions, passed in 2021 a law that prohibits state and local government agencies from engaging in civil immigration detention, and also prohibits any private detention facility in New Jersey from entering, renewing, or expanding a contract to provide private immigration detention. So it didn't actually cause any contracts that were in force to end, but it did say you can't enter into a new contract. And so there are two claims that the Core Civic, the private incarceration company, brings, and the first is called intergovernmental immunity. It's a kind of it's not necessarily a constitutional doctrine that's on the tip of everybody's tongue, but it affects and polices the extent to which the federal government or arguably those who contract with the federal government can be regulated. And then the second principle is preemption, which everyone is probably a lot more familiar with. Federal law is the supreme law of the land. If Congress passes a law that expressly or impliedly preempts a state law, Congress wins. So the arguments in that case were, one, Congress through the INA has preempted New Jersey's law, and the sort of response to that is, well, if you look at the text of Congress's law, actually, it doesn't really say any of that. It tells federal officials that they can consider appropriate places of detention. It doesn't say that those places must be available. So then the analysis kind of turns to this intergovernmental immunity doctrine. And everybody agrees there are two things under that doctrine that you can't do. You can't directly regulate the federal government, and you can't discriminate against the federal government. So if the state can't treat itself better than the federal government, for example. But the sort of doctrinal constitutional question this case breaks out is whether there's some sort of third bucket, really, where some sort of indirect burden on federal operations or on contractors who want to contract with the federal government, whether that rises to the level of an intergovernmental immunity, or whether if you find that there's no direct regulation and there's no discrimination and Congress hasn't hasn't stepped in to preempt, that is kind of the end of the analysis. So our oral argument on that was held in the Third Circuit earlier this month. Again, we'll find out what the Third Circuit thinks about this dispute between the parties in the presumably in the months ahead. I know I only have a few minutes. I did want to touch on a few other things just going on in New Jersey constitutional law. So I'll just talk about two cases. One is about Mount Laurel doctrine, and the other is about the takings clause, which is not always a celebrity in constitutional doctrine, but can have some really, really important effects. So on Mount Laurel, I think everyone probably knows about 50 years ago, the New Jersey Supreme Court held as a matter of state constitutional law that municipalities can't, through their land use regulations, or have to basically make realistically possible the opportunity for an appropriate amount of housing for people, regardless of those people's income. The first 8 years, there wasn't a ton of compliance. They fashioned a judicial remedy known as a builder's remedy to enforce that, though they also invite the legislature to step in. In 1985, the legislature does step in, passes a landmark law called the Fair Housing Act, does a number of things, including creating a body that people may recall called COA, which functions for a number of years. The Fair Housing Act itself gets challenged in a case called Hills Development versus Bernards, gets upheld by the Supreme Court in 1986. COA functions for a number of years. Around the end of the 1990s into the 2000s, it starts breaking down. Its rules expire. It's not able to promulgate new rules. Some of the new rules get struck down. Eventually, fast forwarding a bit, the New Jersey Supreme Court basically declares that COA has become non-functioning. It's become, in their words, moribund. And so they lift the sort of requirement or the obstacle to proceeding in just directly in court that COA had previously provided, often known as the exhaustion requirement. They basically say, we're going to lift that requirement. People can go into court. You don't have to wait for COA because COA has not been functioning for a little while. So then you have a number of years of litigation on affordable housing through the state courts, some 300 declaratory judgment actions, a lot of significant proceedings. Judge Jacobson in Mercer County issues a 220-page opinion after a lengthy trial that really establishes a methodology and calculation of allocations, which ends up being a model for future legislation. And that future legislation is the amendment to the Fair Housing Act that gets passed in early 2024, Chapter 2, I think. And so that law does two things, or it does two buckets of things. The first bucket is substantive. The second bucket is procedural. As to substance, it provides more sort of clarity around the formulas for calculating affordable housing obligations, both in the present and prospectively, it creates an exemption for certain qualified urban aid municipalities. from prospective need obligations. And so and those are, it has a definition of when something is a qualifying urban aid municipality. But basically it's those that are designated to receive state aid and meet one of 3 criteria. And so procedurally, then the law also creates this new alternative dispute resolution program called the Affordable Housing Dispute Resolution Program, which is in a way looks a bit like COA, but it's housed in the judiciary. But it's a voluntary program that municipalities can go into and seek sort of a stamp of approval of compliance. And if they do that, if they operate, it then protects them from litigation the way COA did until COA became non-functioning and the Supreme Court lifted that that block. So towns can go into that ADR program. They don't have to. They can still go to court and just seek a declaratory judgment action the same way they could before the amendments were passed. And they can also just go through their own compliance measures and defend any lawsuits that get filed against them. But those amendments to the Fair Housing Act have been sued now by a number of towns. There's been some litigation in each of the New Jersey courts at this point, and there's actually recently been a federal action filed. The core constitutional claims, and I'll just run through them quickly because I'm short on time, are a kind of claim about what Mount Laurel requires and whether or not the amendments actually exceed the general welfare clause of the New Jersey Constitution or exceed what is required to implement Mount Laurel. Whether the exception for qualified urban aid municipalities violates the Equal Protection Clause or violates equal protection rights under the New Jersey Constitution, whether it qualifies as special legislation, and then a sort of separation of powers fights, primarily about housing this dispute resolution program in the judiciary. COA was not in the judiciary. It was under the executive branch. It was an in but not of agency, but it was not in the judiciary. So there's a kind of separation of powers question. But can you put this in the judicial branch, and can you who can you appoint to it, and is there an unconstitutional delegation of rulemaking authority? So again, those claims working their way through the New Jersey courts. There are other claims that I won't go into because they're not constitutional, and this is a constitutional CLE, but are currently making their way through the New Jersey courts. But that is what's going on in Mount Laurel today. And then last but not least, the takings clause, which, as everyone knows, says that private property may not be taken for public use without just compensation, has been challenged by a group of hospitals who are challenging a provision called the charity care provision, which says under state law that no hospital can deny admission or appropriate service based on a patient's ability to pay or source of payment. And so that means that if someone shows up at a hospital but has no ability to pay, the hospital has to care for them anyway. And it means, as the hospitals point out, that there are certain physical items that might have to be given to that person free of charge. So even down to a Band-Aid, right? If the hospital has, X number of Band-Aids, some of those Band-Aids might have to be given to someone for free. So the hospitals, these kinds of programs have been challenged in the past under the regulatory takings framework, which people sometimes call Penn Central. And that's a test that was really established by the Supreme Court. Throughout the 20th century, it's a fairly flexible test. You all probably remember from law school, it has these 3 factors: economic impact, interference with investment-backed expectations, and the character of the government impact. The hospitals, and in the past, hospitals have challenged these kinds of programs as regulatory takings. Here, the hospitals are primarily looking at a different branch of takings doctrine, something called per se takings, which has historically really been understood for situations where there's a permanent physical occupation of the property or where the property has been deprived of all economically beneficial use. But the hospitals are looking at some recent U.S. Supreme Court cases, like a case called Cedar Cove, and are basically saying, well, the way we read these cases, the fact that you're requiring us to have people on our property who can't pay us, and you're requiring us to give them things like even the Band-Aids, that itself might be a per se taking. Forget about the regulatory taking framework. So what this case is really looking at under state and federal constitutional law, but it's litigated in the state courts, is kind of what does the per se takings doctrine mean in that kind of situation, and especially when, as here, you have an industry that's a public accommodation. The state has noted in defending this that there are other things like this too. There are pro bono requirements, there are rent controls, there are price controls. There are many other regulatory laws that require property owners to buy and often dispose of single-use items like a smoke detector or a fire extinguisher, gloves in a restaurant. So we're going to learn in the months and years ahead kind of what the takings clause means for regulation going forward. But I think this case is Englewood Hospital is going to be a really important first kind of look at that under state law and in the context of a law that seeks to ensure that hospitals continue to provide their historical function of caring for everyone, including the poor. So with apologies for going a little bit over, that was my intro kind of overview of kind of 5 big cases going on right now.
No, not at all. Thank you. Thank you very much. And thanks for circling back to New Jersey to talk about those cases. Mount Laurel has been a huge doctrine and discussed in the legal services committee for forever. And that charity care case rather, also has our attention. So shifting over, Ezra, I know the ACLU has been, ACLU New Jersey and the ACLU has been very busy these days. And we've talked about some of the efforts your organization and others have been involved with. One of the pieces of conversation has been the challenges to the recent executive orders along the lines, and then including with voting rights cases. So can you talk a little bit about that?
Sure, thanks, Akil. And first, before I start off, I noticed in the Q&A or chat, I think one of our attendees, Ann Bowen, I think said that she'd listened to the oral argument in the birthright citizenship case and found it incredible. And frankly, each of you would be doing a favor to yourselves if you listened to Jeremy Feigenbaum's argument first in the Core Civic case that Michael talked about down in the Third Circuit, and then just 2 weeks later, his argument before the Supreme Court in the birthright citizenship case. They were phenomenal arguments, really made me feel proud that he was representing the state of New Jersey. And I think you would enjoy yourselves if you listen to those, and they're easy to find. As Akil mentioned, my job as a Director of Appellate Advocacy at the ACLU of New Jersey is relatively new. I spent the last 10 years actually commuting weekly from New Jersey to Washington to run the National Voting Rights Project for the Lawyers Committee for Civil Rights Under Law. So I'm going to begin with a discussion of an executive order that has to do with elections. And it's an executive order that's somewhat, I would submit, dishonestly titled Preserving and Protecting the Integrity of American Elections. It was issued by President Trump on March 25th, and it does several things. The first is that it attempts to mandate proof of citizenship for those who use the federal voter registration form. And it purports to do that by directing the Election Assistance Commission to, within 30 days, mandate proof of citizenship documentation with the federal election form. It also attempts to curtail absentee voting by directing the Attorney General to take steps to stop any state that accepts absentee ballots that are received after Election Day, even though if they're postmarked on or before Election Day, and to take steps to withhold federal funds from states who have that practice. It also sets up directives to Department of Homeland Security and other agencies to review state registration vote rolls in an effort to remove those whom they say are not citizens and are voting illegally. And finally, it instructs the Attorney General to take such steps as she deems necessary to stop people who are not entitled to vote from voting or from registering to vote or casting their vote. And clearly something that will lead to the intimidation of voters, perhaps predominantly voters of color. The ACLU and several other organizations filed suit in United States District Court for the District of Columbia in an effort to stop this executive order. That case is pending. However, they did obtain an important piece of preliminary injunctive relief just, I think, about 3 weeks ago against that first part of the order. And it's important to go into it. That's the part of the order that directs the Election Assistance Commission to mandate documentary proof of citizenship with the federal registration form. And as the court said in issuing the preliminary injunction, the president does not make the laws. The president's job is to enforce the laws. And in order to ascertain whether an executive order is enforcing the law or making the law, there are standards that the courts apply. And the standards go back to the Youngstown Steel case, where the United States Supreme Court enjoined President Truman from breaking the steel worker strike. And it's based on a concurrence by Justice Robert Jackson, who basically set up a group of standards that said, if the president is acting pursuant to an express grant by Congress in issuing the executive order, then the president is operating at, in this case, his highest authority. However, if the president is doing so contrary to an act of Congress and without authorization from Congress, the president is operating at his lowest authority. And in the context of the documentary proof of citizenship and the Election Assistance Commission, as the court went through this examination, first of all, the Constitution very expressly places time, place, and manner considerations for federal elections in the hands of the state, subject to override by Congress. There is absolutely no room for the president to make the law under the Constitution relating to federal elections. So for that reason, there was no constitutional basis. Next question the court looked at, well, is there a statutory basis? And the court said, well, first of all, you have the National Voter Registration Act, which, among other things, mandated the use of a federal registration form. And as construed in the case of ITCA versus Arizona, United States Supreme Court case about 10 years old, written by Scalia, that statute preempts the states from requiring a documentary proof of citizenship. And therefore, because documentary proof of citizenship is not required under the federal form. So could it be created? Could it be required? Sure, it could. If the Election Assistance Commission that was created by under another act of Congress, the Help America Vote Act, so decided. But the Election Assistance Commission is a really unique entity. It is by statute a 4-person commission, 2 Democrats and 2 Republicans, and they need 3 votes to do anything. And so they can't be directed by the president to do something. So for that reason, again, the court said that this executive order fails. At oral argument on this issue, the government for the first time raised the issue, well, Article 2 vests all executive power to enforce the laws in the president, and that's what this is about. And the court said, no. First of all, we don't want to hear this because it's the first time you're raising it. But if we were to hear it and decide it, you still can't win there because there's nothing in this, there's nothing here that unduly restricts the president from enforcing the laws, because the president, again, does not have the right to make the law as to documentary proof of citizenship. So that's the first executive order that I wanted to cover. The second one I'll do very, very briefly, but it's based on the same sort of principle. It comes up in the, first of all, by the way, the first case I was talking about was League of Women Voters versus Trump in the United States District Court for the District of Columbia. Now I'm going to be talking about a case, the American Federation of Governmental Employees versus Trump, which is in the Northern District of California. And in that case, dealt with the executive orders that and other acts by the administration that directed agency heads to initiate large-scale reductions in force. And again, relying on the Youngstown Steel, the court in Northern District held that plaintiffs were likely to succeed on their claim that the executive order was outside the bounds of the Constitution because the president has neither the constitutional nor the statutory authority to reorganize the executive branch. The court went into the history of attempts to reorganize the executive branch. President after president, including President Trump in his first term, went to Congress to ask for permission to reorganize the executive branch. Sometimes they were given it, sometimes they were not given the permission. But as the court said, to make large-scale overhauls of federal agencies, any president must enlist the help of his co-equal branch and partner, Congress. Federal courts should not micromanage the vast federal workforce, but courts must sometimes act to preserve the proper checks and balances between the three branches of government. And the third case that I wanted to highlight in context of executive orders is the Perkins-Coie case versus the United States Department of Justice, also in the United States District Court for the District of Columbia. I think you're all aware of the outrageous executive orders that were issued by this administration and that purport to stop law firms from contracting with the federal government, from using their security clearances to deal with the federal government, indeed from entering any federal offices. And Perkins-Coie was one of the firms that was targeted in one of these executive orders. As a matter of fact, the executive order was entitled Addressing Risks from Perkins-Coie. It made certain findings that Perkins-Coie had engaged in dishonest and dangerous activity, that had showed unethical lack of candor and had racially discriminated against its own attorneys. And some of this apparently flowed from the fact that Perkins-Coie represented Hillary Clinton in some of the election disputes, that it had also represented a transgender military personnel in response to the administration's executive order that banned all transgender personnel from the military. And this was apparently the basis for the executive order. Now, as you know, certain law firms who were also targeted decided to work out some sort of deal with the administration. Perkins-Coie did not, Jenner Block did not, Wilmer Cutler did not, and those three firms filed suit. The holding of the court in this case, and again, this is an opinion that's really worthwhile reading, the court actually granted summary judgment to Perkins-Coie. The court held that the First Amendment is violated, not only as to the firm, but as to its clients due to viewpoint and discrimination. The court held that the representation of clients is a First Amendment right of the firm, that representation of Trump's adversary implicated core political speech, that working with George Soros, a funder of Democratic and other and some liberal entities, was a core associational right, that the law firm had a protected First Amendment right in favor of diversity, which I think is really, really important, found that the government's actions were retaliatory and that the retaliation was linked to the First Amendment. The court also found that it violated due process. It violated the firm's rights under the Fifth and Sixth Amendments to have counsel of their choice, and it denied equal protection by singling the firm out for unfair treatment. And I just want to quote from this case because the opinion is just marvelous. Using the powers of the federal government to target lawyers for the representation of clients and avowed progressive employment policies in an overt attempt to suppress and punish certain viewpoints is contrary to the Constitution, which requires that the government respond to dissenting or unpopular speech or ideas with tolerance, not coercion. Simply put, government officials cannot use the power of the state to punish or suppress disfavored opinions. And finally, No American president has ever before issued executive orders like the one at issue in this lawsuit, targeting a prominent law firm with adverse actions to be executed by all executive branch agencies. But in purpose and effect, this action draws from a playbook as old as Shakespeare, who penned the phrase, "The first thing we do, let's kill all the lawyers." Eliminating lawyers as the guardians of the rule of law removes a major impediment to the path of more power. And with that, Ronald or Akil, I'll turn it back to you.
Wow, Ezra, great points. And early in your presentation, you made a point that I just want to make sure everybody heard it. The president does not make the laws. So by way of these executive orders, it's got the enforcement of the law, not making the law. Pass it over to Professor Chen. You've been following along the conversation, and I'm sure is ready to lead us in some more conversation around some of the more important cases.
Thanks, Akil. As you noted, like at least the past 15 years or so, I've done a review of a Supreme Court review on constitutional issues at the Lawyers Conference for LSNJ. But switching it to this panel format probably would make it impractical for me to do a blow-by-blow. And therefore, what I thought I would do is maybe pick up on some of the constitutional issues that I don't think I'm making any political statement here. The last a little more than 100 days have caused a huge influx of constitutional issues before the public consciousness. And I just thought I would address some of them that are clearly up there and are on people's minds, although they not, unlike the birthright citizenship case, which has been argued, and some of the cases involving detention or removal of immigrants from the United States, haven't gotten all the way up to the Supreme Court yet for some decisions, but we're waiting for them. So the first one I wanted to talk about is the extent of the president's appointment power, and implied in that is his power of removal of officials within the executive branch, which has certainly come up as President Trump has removed members of quite a few executive agencies from the, for instance, the NLRB, the Merits Protection Systems Protections Board, a whole host of others. And the question is, to what extent is the president constitutionally empowered without restraint to be able to remove a member of the executive branch? The court decided a case some years ago, now say more than 80 years ago, and I think in Ray Humphrey's executor, or sometimes Humphrey's executor, versus the United States, in which, while recognizing that generally the president has the power to remove any member of the executive branch without cause, it crafted a type of exception, and how you characterize, I suppose, it can be a little bit of interpretation, but it's usually thought to apply to situations in which Congress has provided for some type of job protection, such as, for instance, removal only for a cause, for multi-member entities like the NLRB, the Federal Trade Commission, et cetera, and that have been delegated some quasi-judicial or quasi-legislative functions. And under that understanding, Congress has provided for statutorily for some type of job description for a number of entities, even though located within the executive branch. Gwynne Wilcox, who was in the chair of the NLRB, I'll just by way of information, a graduate of Rutgers Law School, was removed by the president summarily, and she argued no. She brought it to court. I fall within this exception by Humphrey's executor, created in Humphrey's executor. The district court initially entered a preliminary injunction in her favor. The Court of Appeals for the District of Columbia, it went back and forth. One panel predicting, well, Humphrey's executor is going to get overruled, so we're going to stay the injunction. The en banc court said, no, we applied the Supreme Court's presence as we find them, and we will leave it to the Supreme Court to overrule the case. But then finally, Chief Justice Roberts issued a stay, which is still in effect, and it's unclear when those cases will actually get to the case on the merits. But for right now, the Trump administration is certainly asking the court to overrule Humphrey's executor. Some people think that it took half a step in that direction in a more recent case, Sela Law Group versus Consumer Finance Protection Bureau, in which it held the president had to have the unilateral right to remove, in that case, which is unilaterally the director. It wasn't a multi-member body. It was one director who exercised considerable policy-making powers. So whether the president is going to be able to engage in all these wholesale removals of entities that, including the independent agencies, it's not the LRB, the Federal Elections Commission, the FTC, possibly even the Federal Reserve Board, although he hasn't gone that far yet, perhaps for political reasons, is going to be an issue that that the court will, I suppose, eventually resolve, and we'll find out whether Humphrey's executor exists and whether the type of job security that Congress assumed those members would enjoy when it created certain entities like the NLRB or the EEOC, which is another entity that he's removed entities from, will last, is going to be a very important question. That sort of leads me to the second issue that I wanted to bring to everyone's attention, which is the amount of deference given to administrative agencies. I think any lawyer who's been watching the court recently realizes that it has been tending towards imposing more limitations on the ability of administrative agencies in the executive branch to engage in policy making of its own without more explicit congressional authorization. It's created this major questions doctrine that requires that before an agency can adopt a new rule or policy pursuant to a general regulation enabling clause under the statute that created it, it first has to show that this was either clearly the specific intent of Congress, or it needs to get specific congressional authorization for that. That was EPA versus West Virginia. And we also know that last term the court overruled the doctrine of administrative deference, so-called Chevron deference, in the Loper-Bright case, such that administrative agencies no longer get deference in the way they interpret the statutes that they deal with. The courts now review the legal issues presented de novo, which, as a practical matter, may make it more difficult for administrative agency. That, combined with the major questions doctrine, is going to make it more difficult for administrative agencies to adopt and enforce regulations. The way I link those two is this, and this is a question that I think is coming down the road. Let's say that the court overrules Humphrey's executor and finds that the president has the unilateral right to remove any member of the executive branch, including a member of the NLRB or the EEOC. But these were agencies that were created by Congress and given powers in the legislative and judicial, quasi-legislative and quasi-judicial areas. In other words, not necessarily performing particular executive functions, but of functions that otherwise might be performed by one of the other two branches of government. But Congress vested that power in these agencies, assuming that they would have some measure of protection against unilateral removal by the president. Would Congress do the same thing? Would it grant the power, those powers to those agencies, now knowing that the president had the ability to remove with advice and consent of the Senate, put new people on? And that I just give you as an open question. In the SELA law case, the court found that they didn't have to resolve that because Congress put in a sort of a boilerplate severability clause that found if one clause was the rest of the statute should apply, and therefore the Bureau could continue to function even though it declared one portion to be constitutional. I did a quick check, and I'm not going to guarantee this, but certainly for some of the older agencies like the NLRB, which was founded in the 1930s, or even the EEOC, which I think was founded by the Civil Rights Act of 1964, Congress may have not even thought to put in one of those general severability clauses. It didn't occur to them. And therefore, we generally won't know whether Congress intended to delegate that type of power to an administrative agency without those protections. That's going to raise a really sort of, in a way, an irony that in some ways, obviously, the Trump administration is trying to claw back on the extent of the power of the regulation of the federal government. And indeed, those who profess conservative values, this has been a question for a long time as to whether the administrative agencies had gotten out of control. Although in this case, I don't know how, you'll have to ask him, how President Trump would feel about having his own administrative discretion, executive discretion, somewhat curtailed if it turns out that the agencies he is now controlling may no longer have the extent of the powers that Congress delegated to them, depending on whether this new method of selecting members is upheld or not. There was one case this term that the court was going to examine the so-called anti-delegation doctrine anew. This is a doctrine that, since the Lochner era ended, was more or less non-existent. The notion that Congress could not, even if it wanted to, delegate its legislative powers to an administrative agency, so long as it articulated a, quote, intelligible principle by which that agency would adopt new regulations. And the intelligible principle requirement was interpreted so broadly as to really almost anything that passed the laugh test would be an intelligible principle. There was a case, FCC versus Consumers Research, that was argued last month, in which the question presented is whether the court should rethink the anti-delegation doctrine and actually require Congress to make a clearer articulation of the powers that it was granting to administrative agencies. Now, most commentators, I read the transcript, and most commentators actually think this may not be the case, in which the court does a wholesale rethink on the anti-delegation doctrine. Although a number of the justices, I think Justice Gorsuch, Justice Kavanaugh, have said in other contexts that it should be rethought. So I think it's if you think about it, all these different doctrines, but the executive's power to remove members of the executive branch, combined with the nature of the delegation of powers and the power of administrative agencies to adopt regulations that make new policy, they all in a way sort of intertwine. So I just bring that to everyone's attention as to a dynamic that we really have to be on the lookout for in the years ahead. That's not going to happen immediately, because I think they're going to let that percolate. A term I will use I'll borrow from the oral argument last Thursday in the birthright citizenship case. But they will be coming up, I think, fairly soon. The last thing I just wanted to talk about, because as I said, it's probably not practical for me to give my best hits of what the Supreme Court is or just has ruled upon. But there's one area three cases that I just wanted to mention, and then we'll go sort of into our structured Q&A. And they have to do with the area of the religion clauses, religious freedom. And the court has taken three cases that could have some significant effect on on the way that the religion clauses in the First Amendment are interpreted. And I think they've all now been argued fairly recently. The first one is Catholic Charities Bureau versus Wisconsin Labor and Industries Review Commission. That's a case in which Wisconsin denied Catholic Charities, a charitable organization, but obviously operated by the Roman Catholic Church, an exemption from paying, I think it was state unemployment insurance, which is an exemption it did grant to agencies that were founded for a religious purpose. And the reason that Wisconsin denied that to Catholic Charities is that the work, although it obviously was motivated by a religious goal, the work that it was actually doing in providing relief to the underserved, what Wisconsin said was secular in providing that type of assistance, and therefore it was not, it itself was not acting for a religious purpose. Well, Catholic Charities sought review in the Supreme Court, and that case was argued. And I've got to say, I think most observers say the court is going to find that Wisconsin cannot deny that exemption to Catholic Charities. And that seemed to be getting some traction across the members of the court, no matter what their facial identification. Only the theory is that it's really not possible for a government such as Wisconsin to decide whether an agency is, whether its purpose is sufficiently religious. That's essentially, in one way, amounting to distinctions between one religion over another. In a way, it's sort of having a government agency or a court essentially determine the centrality of religious belief in determining whether they're entitled to an exemption or not. And so I think I will go out on a limb and say I think the court is going to tell Wisconsin it has to grant Catholic Charities that exemption. And that one may get fairly widespread support. Another case that they argued last month, Mahmoud versus Taylor. This is a case where a school system had included certain books that were referred to LGBTQ persons, I think also transgender persons, as part of their curriculum. That was introduced in the K to, I think it was K to 8 in that case. It was younger school children. Initially, they provided an opt-out system whereby parents who objected to their children being exposed to those books could have their children excluded, but eventually the school system ended that exemption system. I think they said it was just administratively too burdensome to apply, and therefore there was no such provision. The parents then brought this lawsuit claiming that requiring their children to be exposed to these books violated their freedom of religion. I guess the question is, what was decided below is, was it doing so, did that impose a significant burden on religion? The court below actually found that it did not, that it was it was a neutral practice of the schools that might have had an indirect effect depending on what one's religious beliefs were, but they thought that it was it was not directed at religious beliefs, and therefore it did not impose a significant burden. Again, that case has been argued, hasn't been decided yet, but a lot of observers predict that the court will disagree with the lower courts, at least on the initial finding, as to whether that regulation amounted to a significant burden or not. And that I think what they will probably note is that you grant exemptions for a lot of other things, for health, health and for gym classes, for other reasons. You're not granting the exemption to religious for religious belief, and that amounts to a type of discrimination against religion. And therefore, to meet that type of that type of regulation would have to meet strict scrutiny, whereas at least under the existing rules, that's under Supreme Court doctrine, if it were a facially neutral regulation, would only have to meet a rational basis. The court has been musing with the idea whether it's going to rethink the Smith versus Division of Employment Services, the so-called Peyote case, on whether a facially neutral regulation that indirectly impacts upon religious activity should still be scrutinized under a rational basis test. It's been making noises about that frequently, and it's taken a number of cases, but it hasn't yet done it. And what it would substitute that test with now, it's a little unclear. It may not find that this is the case in which it's going to rethink that jurisprudence as well, because it may find that this is essentially discriminatory towards religion and therefore apply strict scrutiny on that basis. But then it would probably send it down to at least determine whether the state has shown a sufficiently weighty interest to overcome that burden or not. The last religion case I wanted to mention, St. Isidore, it was consolidated cases, but the one that a lot of people refer to it under is St. Isidore Seville Catholic Virtual School versus Drummond, this case out of Oklahoma. Oklahoma, like New Jersey, has a provision for charter schools, and St. Isidore, which is operated by the Roman Catholic Church in Oklahoma, applied for this funding and was turned down because one of the regulations was that you can't engage in sectarian conduct, or certainly in your curriculum in its parochial school. Clearly, that was part of its mission. So the issue is based whether a parochial school or a religiously affiliated school should have access to federal funding, which could very well really change the landscape on the jurisprudence on funding for religiously affiliated schools. The usual argument is, and certainly in New Jersey, if you ask anyone what is a charter school, the response will be a charter school is a public school. And therefore, is saying that a public school cannot engage in religiously sectarian conduct would not raise a question, because indeed under the Establishment Clause, public schools are forbidden from doing so. The argument there in Oklahoma is that St. Isidore School is really a private school, and the mere fact that it is seeking funding from the state government in this way does not make it a state actor, and therefore that changes the dynamic. So a lot of this does come down to how you properly characterize charter schools, as public schools or as private schools. If St. Isidore prevails and charter schools or systems that have similar funding, and maybe it's similar to New Jersey's, are really private schools, and therefore you can't discriminate against a religiously affiliated school in how you fund it, that could obviously completely change the landscape and how education is funded. I guess for the schools, states that have those programs would probably have to make the choice between not having a charter school system at all, or else funding parochial schools, which would talk about changing the funding formulas. I can't even imagine what that would do in New Jersey. Abbott v. Burke would come back to rear its head. So those are cases I think I am certainly keeping my eye on. And all right, well, we're way over time. I'm wondering, Akil, I'll ask your guidance on this. We had reserved some time for what I'll call directed Q&A by me. But since we've only got 20 minutes left, do you want me to start out, or do you want to start taking questions from the audience? I'm sure
They're starting to come in, but why don't you start?
All right, well, let me start out.
Yeah.
I'm going to ask both my panelists to reflect on this. I'm asking, these are both sound like 30,000-foot questions, but I think they both have relevance to some of the cases that we've been discussing. So there are two concepts that at least lawyers almost all learned in law school, and I'll name them: federalism and standing. And when I went to law school, it was thought by those who espoused progressive viewpoints that federalism was something we wanted to, that was really a way to avoid imposing, in other words, to allow states to impose restrictions that we might not agree with, and therefore we tended to view federalism with a bit of a skepticism, and standing with similarly a way that the courts might avoid ruling on the merits of a civil rights or civil liberties question. But the fact that we have here now, at least in New Jersey, an attorney general's office that is suing the federal government with vigor, shall I say, and in the midst of doing so is asserting the standing, the particular standing of the state of New Jersey as a proper plaintiff in this, in ways, and I will join my everyone else who said, if you have a chance, listen or read the transcript of Jeremy Feigenbaum's argument last Thursday. I will ask Michael not to tell Jeremy I said this, because it will go to his head. But his argument was indeed, I thought, absolutely masterful, and particularly in the area of how he asserted the special interest of the states to litigate the issue of birthright citizenship in a way, in order to justify a nationwide injunction in a way that might not apply if this had been an individual a person bringing this action, where an individualized injunction might apply. So I'm just thinking, in all these areas, do you have any reflections? And we also have, talking about federalism, we have a case where the state of New Jersey is asserting what was deemed to be a very conservative doctrine, the anti-commandeering doctrine, in a way that says we do not have to cooperate with you in the enforcement of federal immigration law. So I'm wondering, are old labels or conceptions about these doctrines sort of outmoded, and should we view them just as neutral tools that any lawyer uses when the opportunity arises? And if either of you have any thoughts on that.
Well, I think you've got a good panel on this, because you've got a government lawyer on the panel, so you're not going to be surprised. You might get a sort of a pro-government view, but you've got Ezra, who can also maybe may want to problematize some of the things I say. So I think of it as, I do think of these doctrines as being in affecting a valuable constitutional balance, and I think they've done that for some time. So if you go back to, Justice Brandeis, right, the great, perceived by many as like a great early liberal justice, he's the person who coins the laboratories of democracy concept, and the idea that the states can regulate above a federal floor, can actually protect rights above a federal floor, and can take action above a federal floor. And you have folks like Supreme Court Justice William Brennan, former New Jersey Supreme Court Justice William Brennan, who speaks out about state constitutional law in the 70s. That gets echoed today by Chief Judge Sutton of the Sixth Circuit, who sits in Ohio, talking about state constitutional law. So I think there has been a long and proud tradition, really, of states operating as, under our system. States are constitutional sovereigns. There is true dual sovereignty. States can take their own action. And I think the federal system has long rightly recognized that. And of course, the federal courts have been open when that discretion runs into a violation of federal rights. And of course, there have been critiques of standing as a way to prevent those rights from being vindicated. But generally speaking, I think those doctrines have allowed a sort of healthy balance where the states are not required to be a monolith where Washington just decrees how everything works everywhere and then every state has to follow suit, but rather can experiment in that laboratories of democracy kind of way that, again, Justice Brandeis was the one who gave us that conception almost 100 years ago. But I'll let Ezra give, a counterpoint.
Well, not necessarily a counterpoint, Michael. And before I do, I just wanted to correct one thing. I think I glibly described the title of the executive order as being dishonest, and that's really not fair. What I meant to say was that instead of effectuating preservation and protection of election integrity, in my opinion, it would have the opposite effect. Moving to your point, Michael, and Ron, we've been there before in terms of federalism, and you're right, Ron. The states raised federalism in opposition to desegregation. The states raised federalism in opposition to the Voting Rights Act. But I think we have to try to develop consistent principles, because you don't want the Constitution to depend on whose ox is being gored necessarily. And I think, Michael, when you talk in terms of states having the power to go beyond what the federal Constitution says, in terms of giving to, for example, New Jersey citizens rights and privileges that they have because they're New Jersey citizens under the New Jersey Constitution, or that they're in New Jersey under the New Jersey Constitution, whether they're citizens or not, that is an important, and I think that is a position that we can all agree on. I think that if you look at the cases that countered federalism with something else, it was typically the 14th and 15th Amendments, which trumped the argument of federalism, because the 14th and 15th Amendments are so supreme in the constitutional regimen. So I think that we could have common principles that do not depend on who's in power, who's not in power, but basically really concrete statements of constitutional law.
Great. I will simply add, since I mean, both Michael and Ezra mentioned the state constitution, which is a subject of particular interest to mine, and therefore probably to lawyers in New Jersey, because we have a state Supreme Court that has historically frequently used the state constitution as an independent and very often a greater source of individual rights than the federal constitution. And federalism, I guess, it does take a somewhat of a different term. And Michael, just out of curiosity, because I have not been following the Englewood Hospital cases much as I should have, I'll read up on that. Have they raised both a state constitutional and a federal constitutional claim under the Takings Clause?
Ron, don't quote me on it. I'm pretty sure they raised both, but it's the two have been understood, I believe, to be coextensive. So the litigation has basically been under the federal case law, because I haven't seen, I think, a case where the state Supreme Court has diverged from federal takings case law.
I think that's certainly right. So far, it's one of the provisions that has not been, in which a significantly different interpretation has been given under the state constitution. I can't think right now of another case that the state Supreme Court has taken very recently that might involve some independent constitutional rights, independent rights under the state constitution, but unless I'm forgetting something, but maybe they're just taking their breath. The court has undergone quite a bit of turnover recently, so it's something I would be watching for in the future.
There's
Or
been
you can't-
a couple in the First Amendment. There's sometimes litigation about this. If there's a case called State versus Fair a couple of years
Yes,
talk about whether or not to, they didn't. There's a case called State versus Usachenek where they do use the state constitution actually.
And in the Fuse and Ballot case, I thought the appellate division did undertake a state constitutional analysis.
Yes, they did, and that's currently the certification petition currently pending on that one involving former Congressman Malinowski. All right, well, Akil, we got 10 minutes, so maybe now's the time to start taking some Q&A.
Sounds good. We do have a few questions already teed up, and I'll sort of just take them as they're coming. And this is for you, Professor Chen. Can you touched on this, but can you expound, excuse me, on how we square the theory of the unitary executive with the Supreme Court's abandonment of Chevron and discretion to agency power? It seems these theories are at odds.
Well, I'm speaking just for myself and a little bit off the top of my head. I don't know if the court has completely thought that out and realized that these two concepts might have interface with each other. I'll put it that way, just yet. So because I tend to agree with you, or if one accepts the unitary the theory of the unitary executive, might that encourage the court to be even more demanding about the way that Congress makes clear if it's delegating authority to the executive branch or not? Now, this is purely speculation. I don't think they're going to answer this in the FCC versus Consumer Research case, the so-called the anti-delegation case that they took. They're going to resolve it in some other way. But I think at some point, someone's got to realize that when you affect one, you are somewhat affecting the other, or you could be affecting the approach that the court takes. Because obviously, if you begin to give the president absolute unilateral authority of everything in the that is within the executive branch, including agencies that previously thought to be independent, the court I could see an argument. The court would say, in that case, Congress has to be much clearer as to whether it really is going to delegate that amount of quasi-legislative power or even quasi-judicial power to adjudicate matters to those executive agencies. The answer is, I guess, I don't know, but that's why I raised the question, because I think that issue is going to come to a head.
Yeah.
Akil, I noticed a question about how has the executive branch been about carrying out court rulings?
Yes.
I'd be happy to deal with that because it touches upon immigration, and the ACLU of New Jersey has been very, very active representing Mahmoud Khalil before the United States District Court. We have right now temporarily stayed his deportation, also representing students whose SEVIS, Student Exchange and Visitor Information System status had been terminated, and we've gotten a preliminary injunction against that. I really recommend that people take a look at the opinion in Abrego Garcia, the person who was erroneously sent to El Salvador by admission of the federal government, but is still there. The United States Court of Appeals for the Fourth Circuit, in an opinion written by Judge Wilkinson, who is a relatively conservative judge, basically has put pressure on the government to come up with a detailed explanation of what they're doing. They sent it back to district court, I think they've given them 1 week to say, to specify precisely what they're doing, and to document the requests that have been made to the president of El Salvador to return Mr. Garcia. And that's basically the most that can be done right now. And it's going to be interesting to see how it plays out. But just a quote from Judge Wilkinson, he says, "The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. And I think that what we're seeing right now are the courts uniformly upholding the rule of law over against an administration that seems to be recalcitrant in complying with court orders.
Terrific. And just a follow-up question on that. Anyone on who can speak on this, in terms of putting what we're seeing now in a historical perspective, and then you touched a little bit on this, Mike. Have we been here before, where the level of federalism, the need for people to push back?
Well, I'll defer to Ezra and Professor Chen. I think maybe more on this, because especially Professor Chen has scholarly views on it. But I do think that, you know, the quote that I harken back to, the Justice Brandeis quote, is evocative, that there's always, I think, through our history been a push and pull between you know, a desire for sort of uniform federal law from folks who like federal law, and a desire from the states to have a realm of autonomy as sovereigns, as co-equal sovereigns, to be able to, you know, put in place their own regulations and to experiment with different ways of doing things. And so, you know, at different times, to Ezra's prior point, of course, it's had friends and enemies and critics from different sides. But I think that's kind of built into our federal system. And I think in some ways, at least, to give a more optimistic version of it, I think it's kind of the genius of our federal system, which it's a form of check. We talk a lot about checks and balances at a, you know, sort of horizontally across the three branches of the federal government. But having two unique sovereigns and co-equal sovereigns, and actually saying we're not just going to have one policy for all 50 states, but within what's permitted by federal law, we're actually going to allow the states to experiment and to you know, order things their own ways, is a valuable feature of the system, even when at times we've all had parts of it that I'm sure we haven't liked. But I think ultimately it's part of the genius of the sort of architecture of our system.
Well
You know,
said.
I'm probably in no greater position than anyone else to predict how events are going to unfold. It might be more his question of sociology or history or political science. But I would simply say this. For one, to pick up a little one Michael just said, the legal system, I mean, one of the aspects of the legal system is that it does so pervade our society and culture. And all our institutions really depend upon its efficacy, including the executive branch of the federal government. In particular cases, it may not think it needs the judiciary, but overall, if you don't have, there's something only courts can do. And so it is certainly my hope that eventually, while we're going to apparently have some tension, and perhaps an executive branch that is much more willing than others to press the limits, that eventually they'll see that ultimately you cannot take a position of utter rejection of the rule of law and obedience to court orders, because it won't be in your institutional best interests. And the other thing that, as Michael was saying, is the legal system is pervasive because we have a federal system in which we have a lot of moving targets for anyone who wants to try to disable it. That does mean that we as a legal profession have to be aware of our sort of collective obligation. It is sometimes much easier to say, well, all you have to do is one set of lawyers, they bring it up to the U.S. Supreme Court, and they get a ruling, and I guess that's not going to be as easy. I still hope that in certain cases it's effective, but it's not going to be as easy as it was. So you have to have a legal profession. I mean, by way of disclosure, Ezra is with the ACLU of New Jersey. I'm a member of the National Board of the ACLU. And it's probably, we've been fairly busy litigating, but one thing to note is that we're litigating a lot state by state, and the ACLU can do that because we've got affiliates in every state, and very often in state court, whereas probably we used to litigate more in federal court, and now in state court as well. And when you bring to bear the legal principles of the entire system upon which so much of our fabric of our society is based, I've just got to hope that eventually everyone will realize that we cannot question the essential requirement of rule of law, even though if you open up the newspapers every day, it does seem a little bit, there's reason to question that on a day-to-day basis.
Right on. We want to be respectful. We're at our time. I think this has been a tremendous webinar, and the information that's been provided has been remarkable and very important, especially now. I want to thank our speakers, Professor Ron Chen, Deputy Solicitor General Michael Zuckerman, Ezra Rosenberg of the ACLU New Jersey. Thanks to Rachel, Kelly, Raj, our staff for putting it all together, and thank you for attending the webinar, and hope you enjoyed it. See you next time, everybody.